We welcome you to this webinar on use of blockchain and AI for ODR. Blockchain and AI are among the most disruptive or groundbreaking technologies that will fundamentally reshape how we live, work, and interact. In today's webinar, we intend to discuss how AI and blockchain will reshape dispute resolution, particularly online dispute resolution, and we have experts in the field joining us today to answer some of these questions and to debunk the myths associated with AI and blockchain. I congratulate Center for Arbitration and Research, MNLU, for putting together a webinar on this topical subject matter. A special thanks to Chirag Balyan for taking this initiative and for inviting me and giving me a pleasure to kickstart this webinar by welcoming and introducing our special guest for this webinar, Justice Gita Mittal, Chief Justice, Jammu and Kashmir High Court. Justice Mittal is one of the most loved and respected judges of our country and needs no introduction. But I would not like to leave this opportunity to speak a few words about her as an inspiration and role model for young lawyers. She has always been in the forefront to train young minds, giving them opportunity to learn from her vast experience in a variety of subjects of law. And I must confess that I am one of the beneficiaries of this as being a legal clerk to Justice Mittal while she was a judge of Delhi High Court. She is an example of a successful, righteous, self-made person who loves to lead by example. Justice Mittal studied economic honors from Lady Shri Ram College, Delhi, and did her law from Campus Law Center. She had an illustrious legal practice before she decided to join the bench as a judge of the Delhi High Court. She was also the chair of the Court Committee on the Delhi High Court's Mediation and Conciliation Center. She was appointed as the acting Chief Justice of Delhi High Court in April 2017, and then was elevated as the first female Chief Justice of High Court of Jammu and Kashmir. She has written a number of significant judgments in the field of constitutional law, business law, and human rights. Be it a personal injury, like fracturing her leg, or other pressing commitments, she has never shied away from her responsibilities and had diligently and patiently given a hearing to all the litigants appearing before her. I would be failing to mention that much before COVID and the Indian courts using online platforms to hear the parties, Justice Mittal used video conferencing to hear the parties when she was unable to attend the court due to an injury to her leg. With these few words, I would now like to invite Justice Mittal to address the participants.
Thank you very much, Neeti, for those very, very kind words. I don't know whether they are deserved, but I'm grateful for your kindness and your generosity. My namaskar, assalamu alaikum salam from Srinagar, where I'm sitting just now. I wish I could have been speaking to you from my garden and the lawns and shown you the beauty which Kashmir actually is. But I'm told that the sound would interfere, the sound of the traffic. So I'm inside in my office in my Kashmir residence. My gratitude to the Maharashtra National Law University, to Chirag Balyan, to Neeti Sahdev, and the MCIA for giving me this opportunity to share a few words on this topic, of which I think I must confess I've learned more because of the preparation that I put in to understand the subject matter thereof. Of course, dispute resolution, alternate dispute resolution, and the conventional mode of dispute resolution in courts is something that we are familiar with. But online dispute resolution and the use of tools and techniques in the nature of, AI and the blockchain is something that I think are yet to really kickstart in the courts as well as in alternate dispute resolution. So I have written out a small piece, and keeping in view the time constraints, I will try to summarize it for the benefit of the several students who I understand have joined this program. And I think speaking in front of the experts who are the panelists on this panel is really like showing a candle to the sun. And they will pardon me for my ignorant statements if they happen to come out somewhere or the other. But I have learned a lot from reading about this I've learned a lot from young people, young enthusiasts as Neeti about arbitration and dispute resolution. And I have been a very, very avid advocate of mediation as a dispute resolution mechanism. So, and certainly this ODR platform, ODR, the requirement of online dispute resolution in the current context has assumed not only significance, but has acquired essentiality as we grapple with technology related issues and are looking to find better and more efficient ways of dispute resolution to serve the seekers of justice and relief who are still thronging the courts. The recent pandemic has not only locked us up, it has made us read compulsively about force majeure, watch cat videos, but has also made us meditate. Many certainties have broken down and we've been compelled to look within and our place in the future. So what really is the future of dispute resolution and the legal profession? A profession which, despite its stellar role in societal change, is otherwise hardwired to always look behind in terms of precedent, analogy, custom, and tradition. We've known this for some time now, but the very nature of our profession, that is a legal profession, often makes us averse to change. And as lawyers love to call it, we have become status quoist. But as the adage goes, even if we can't see the future can still see us. We are living in the age of acceleration and disruption. While society and technology are moving leaps and bounds, law and unfortunately legal education as well is struggling to catch up. Technology has universally impacted all aspects of our lives for many, many years now. And now, due to prevailing geopolitical and current social dispositions, it is influencing more aggressively than ever before. Dispute resolution mechanisms have certainly not been able to remain immune from the technological thrust. While we confront this question, the essential egocentricity of the profession, irrespective of the dispute resolution mechanism being used, makes it difficult for us to adapt to a mindset which Richard Susskind appropriately calls outcome-based thinking, an approach of taking a step back beyond oneself and thinking in terms of outcomes and solutions. Just as a person afflicted with cancer has a cure at the top of his priority list, rather than a rock star of an oncologist, a person having a legal problem is usually not looking for a great lawyer. Instead, he's looking for a solution to his problem. We as lawyers and judges merely help him achieve that. With this framework of thought in mind, we argue that even if we overcome the essential backwards-looking approach of our species and look at things in an outcome or solution-based approach, we are still faced with another important question. How are people going to reach out for justice in future? A few words about the traditional courts. Richard Susskind asked if courts are a service or a place. The ongoing crisis has shown us that the answer is undoubtedly the former, a service. The pandemic has forced our hand to think of courts as a service. A lot of the previous hang-ups about courtroom theatrics, the role of grand paraphernalia, a symbolism of the court has fallen away. Every other week, we learn about a new AI-based legal research tool or a computerized justice delivery system that is all set to outperform the judges at their own game. Today, technological advances have enabled computer programs to process speech and natural language. Most judges and court stenos regularly use the Dragon software. One need not look further than their digital assistants, be it Alexa, Google Assistant, or Siri, which process user inputs with relative ease. The question before is whether the use of these technologies can be extrapolated, and is it possible to use them to resolve disputes better on the internet or otherwise? The first factor which we must consider is whether a machine can think. In short, the answer is definitely a no. Unless we can replicate the human brain and its cognitive processing power, only a flesh and blood human being can undertake the act of thinking. Thus, machines cannot function as a human judge. However, another dimension to this question is whether the outcome of a factual input can lead to a judicial decision based on objective reasoning. In my view, perhaps in the next 100 or so years, the computers will outperform judges at their own game, but certainly not today. The perhaps is certainly dominant today. One area where computers do have an edge over humans is the field of computational statistics. The ability to refer to past cases, the nature and value of claims, etc., enables a computer program to predict the outcome of a particular decision better than some human predictions. An example of this is Lex Machina, which was purchased by LexisNexis in 2015 and has been said to be able to successfully predict the outcome of patent litigation in the USA. While the view on computer judges, or given the context of our discussion, computer arbitrators may not change over time, it is interesting to see if these prediction programs can replace a lawyer or a judge or an arbitrator. As lawyers do engage in some form of predictive reasoning, it is conceivable that in the future they might be regarded as negligent for not relying on these tools. Very similar to how doctors are held accountable for not relying on tools like MRIs to support their diagnostics. Speaking of adjudicators, much like humans, they also suffer from biases. These programs might be affected thus by the biases of the engineers who created them. Further, it is likely that only a decision which is delivered by a human judge or a human arbitrator can be considered binding. Nevertheless, would it be too far-fetched to say that a program which predicts a finding with a probability factor of 97% can become the official determination of the court or the arbitrator? While some may argue that machines cannot replace a court of law, others might agree that it is reasonable to put such tools in place for very minor disputes. It is equally likely that these questions might never be answered in our lifetimes, but we must remember to keep an open mind and ensure that our conversation does not result in a failure to make changes. I first experienced technology as a judge of the Delhi High Court, sitting on the original side in 2006 or 7 when Neeti Sachdeva was my law researcher, and we encountered paperless courts. But the real experience of where I was of putting technology to use came in Jammu and Kashmir, when out of a sanctioned strength of 17 judges, I had a strength of 7 judges to be distributed between 2 wings, one in the Jammu wing and one in the Srinagar wing. I had to divide 7 judges amongst 2 fully functional high court wings, and I was very gravely short of judges. So if in the wing where I posted 3 judges, 2 of them recused from a division bench matter, I had to appoint a judge who was sitting in the Jammu wing as part of the division bench. So we adopted a unique formulation from 2018, which was that a division bench of the High Court of Jammu and Kashmir would have one judge sitting in Jammu and the other from Kashmir in Srinagar. And I don't think this formulation or this methodology has been adopted anywhere in the country. Even today, because of the inability of judges to move on account of COVID and the red zone and the green zone movement restrictions, I am compelled to put judges sitting in different cities on benches and have used the technology, the internet and the e-court facility very, very generously and very easily and comfortably. As Neeti pointed out, I fractured my knee very badly in April 2018 and was unable to go to court because the court wasn't disabled able. I conducted my sittings from my living room in Srinagar using technology between the High Court and my residence. Lawyers used to argue from my courtroom while I had the sittings from my drawing room, living room at home. So while technology does have the potential to supplement human memory, logic, and fact-finding, but with over time, I am now skipping over my written paper, which I will share with Neeti, and Neeti, feel free to use it with all the participants. But I'm told that 10 minutes are up and I only have 5 minutes to summarize actually what I have to say. But, technology over time, especially AI and blockchains tools could assist with even factors like empathy and reasoning. The so far as arbitration is concerned, the artificial intelligence assumes great relevance as it would help with the appointment of arbitrators. It enables looking up relevant case laws, which are maybe applicable from the analysis of the written submissions of parties. With the power of data, it would intelligently analyze legal issues involved in the case and look at similar cases in the past and come up with analogies. AI would lead to unprecedented levels of automation in the legal sector, reduce costs, provide access to justice, and many more benefits to the consumer. The recent advancements in machine learning and data processing would be useful in building thorough case strategies, as by sifting through a large number of cases in a short time, AI would help lawyers stay ahead of the curve, as it would also lead to continually evolving case strategy. You see, both AI and blockchain and transition to these technologies would certainly have a very great impact on ODR. One impact would be the constant interpretation of laws. Technology does not discriminate or adapt according to the mood or the individual bias or the interpersonal relationship. Interpretation of laws and jurisprudence would become constant, and decision making would therefore become objective and free from ambiguity. Technology would influence ODR in three very important ways. The first would be that the technology platform for conduct of proceedings and exchange of information would assume reliability. Secondly, it would provide tools and networks for conduct of dispute resolution itself. And thirdly, it would prevent disputes by application of advanced prediction tools and help parties understand their contracts and their disputes and assess the success of litigating or arbitrating or fighting over what needs to be resolved. Artificial intelligence is the answer to the what of it, while blockchain is the answer to the how of it. What can be done is by way of AI tools that a large number of lawyers' functions can be easily executed, looking for relevant case laws. These tools would look up the case law after studying written submissions carefully. It enables better appreciation of laws applicable and also with calculation of damages as well as costs, especially in arbitration. Blockchain would provide secure and efficient platform for hosting these tools by way of decentralized applications. In fact, the AI tools can be executed using simple blockchain programs easily provided in the blockchain networks. Now, we have experts speaking on smart contracts, so I'll skip whatever we've had, whatever I have noted on that. But a few instances of where AI has been used and how it could be used in arbitration. The first example is that of Kira, a powerful machine learning software which identifies, extracts, analyzes text in one's contract and other documents. It would read the contract, which does not give decision over a dispute, but would help understanding difficult and complicated contracts and reduce the understanding to extremely simple formulations. Kleros is another example of a distributed arbitration system. It has been termed as a quasi-judicial system where jurors who volunteer themselves are selected at random. Juris is another example of a blockchain-based dispute resolution system, which is an open code system where parties who have adopted the Juris code in their smart contract have the option to freeze the contract and trigger the dispute resolution mechanism in the event of a dispute. It is a fascinating methodology, and I'm amazed at what technology has been able to achieve and the level at which the ODR mechanism gets triggered off by the parties automatically to take the entire dispute to resolution. These examples are private methods of dispute resolution which allow parties to set the terms and adjudicate on disputes of a contract without state intervention. The two very important principles of ADR as well as ODR. The first is the principle of procedural autonomy, which is extremely precious to ODR process. And the second is the principle of neutrality. ODR and the use of AI as well as blockchain enables a vigorous application of both these, enables a vigorous application of both these principles. Now, technology does not influence the outcome of the dispute resolution. It enables us towards finding the resolution. So what is the contribution which AI and blockchain can make? I have read a very thorough article which very simplistically explains the use of AI and blockchain in arbitral proceedings. Madhvendra Singh has authored the article. He is here to share with you his writing with us. Using big data and machine learning eases stages of discovery and reduces time taken to reach the decision. As I have said, appointing an arbitrator may become a process focused on specific data, which enables us to point out which arbitrator is best suited to the case at hand. Another advantage of using these tools and technology. The technology may impact the process of taking evidence and document production. It enables the parties as well as tribunals to exchange communication, documents, information more instantaneously and in an extremely reliable manner without any possibility of doubt. Witness examination would be reduced to a more efficient and quick method by use of technology like transcripts, lookup searches, and document management. AI can be used in answering technical questions that do not require any human subjectivity, like the analysis of numerous data. An example of this would be determining the market value of shares of a company at a given point of time. Using AI in arbitration could improve the speed of the proceeding, the preciseness of the result reduces costs and makes it free from ambiguities. This would also prevent any discussion post expert determination as to the partiality of the expert, since it will be an unbiased technology program. AI can be used to assess evidence, relevance, and materiality of documents being used in arbitration. It enables a summation of the pieces of evidence produced by parties, and in the context of e-discovery, largely facilitates the process. AI would certainly be more efficient than humans and definitely less prone to mistakes. There is, however, a downside, just as to everything else, particularly in a country like ours, where computer literacy and access to e-resources is still an issue. Technological revolution of our ODR and justice delivery system is possible only if a significant proportion of the legal fraternity becomes computer literate and use of technologies is not restricted to a select few areas. Another major disadvantage of AI is the lack of flexibility and subjectivity, which is sometimes necessary in a dispute resolution. AIs cannot recreate the subjective human perspective that exists in every case. For instance, even though Kira can read the clauses of a contract, it cannot determine the subjective intent of the parties behind the clauses. Then we must remember blockchains and AI are not entirely safe from tampering and are liable to be hacked. So we have to ensure that cyber criminals are unable to drop into ODR proceedings or change or manipulate ODR records, which would severely dent the trust and confidence of the people in the ability of the ODR processes. These processes hold immense potential and must be utilized for reliable ODR in order to mitigate time and cost problems. In the best interest of parties, certainly care has to be taken to ensure that access to justice or dispute resolution is not impeded in any manner whatsoever. But before we take whole hog, adopt these tools and technology whole hog, a few questions arise which need to be addressed. What training arbitrators will need to adopt these technologies? How will lawyers adapt to new skills of advocacy? How will the AI do the thinking and analysis of the issues? Who holds the right to these codes? How will they deal with existing biases? Additionally, some other aspects which need to be borne in mind are contentious legal issues including data storage, protection, privacy, confidentiality concerns, especially client confidentiality issues of the stakeholders must be addressed. What we have always missed when we put in new systems is the lack of a legal framework. Therefore, a specific and dedicated legal framework to deal with the use of blockchain and artificial intelligence has to be put in place. Online services of ODR platform must comport to the national cyber law framework for the country concerned. Cybersecurity, I've already mentioned. Systems for preservation and retention of electronic records which comply with the applicable legislations are required to be put in place. There may be implications of conflict of law, rules, regulations, and standards. There would be issues relating to internet jurisdiction, which may lead to extensive litigation. All these need to be anticipated, if not at a global level, but certainly inter parties, and must be provided wheresoever necessary by legislation or in the agreements between the parties. Another very important thing, which in fact, another system which needs to be put in place is working protocols, rules and regulations to effectively and efficiently work the ODR needs to be put in place. I am of the view that ODR is not going to be restricted to national jurisdictions. We are going to use ODR. We will need ODR at international platforms, especially when situations as the current pandemic arise. Therefore, just as this important conversation which MICA and the Maharashtra National Law University have started is far-sighted, is foresighted and far-sighted. It is essential that for use of blockchain and AI in ODR to be effective tools, we must work out an international convention like the New York Convention or the Singapore Convention on Mediation. This must be taken up on war footing by all the nations and the organizations looking at arbitrations. Before all the issues or some of the issues which I have pointed out, there must be many more, end up in protracted court battles in one jurisdiction or the other. To my mind, it is absolutely imperative that there must be rigorous legal and technical capacity building amongst the stakeholders. There must be holistic adoption of blockchain and artificial intelligence in the ODR paradigm, and problems which arise need to be anticipated and addressed on a collaborative basis, nationally and internationally, for the ODR to be an effective platform, and for AI and blockchains to provide efficient tools and technology in the ODR mechanism. I end here with my heartfelt gratitude to the MNLU and MCIA for hosting this very, very important discussion and conversation and giving me this chance to speak to all of you. My best wishes to all the panelists and the organizers for a very, very successful and a very meaningful discussion. I may not be able to be with you the rest of the discussion, but I will join again, and hopefully will be there I would like to be here to learn mostly from what the huge, expertise which the panelists are bringing. So thank you very much once again, Neeti and Chirag, Balyan, and good luck in your endeavors. And please do look at starting this conversation for a convention, and we will put an end to a lot of cases which I don't have too much time on the bench to decide. Thank you once again.
So, thank you so much, ma'am. On behalf of Maharashtra National Law University, Mumbai and MCIA, I would like to sincerely thank you for sharing your thoughts on what future is going to look like with the use of artificial intelligence and blockchain. We are sure to take forward your suggestion that we should work on some international convention, and definitely we would like to take it forward under your guidance. If I have to say you my single or the most important takeaway which I got from your address is the open-mindedness and the keenness to learn and adapt to change. And I think that's one thing which is really going to open up the future prospect for the artificial intelligence and the blockchain. And we are very sure that, and I personally feel that Jammu and Kashmir High Court is so privileged to have you, that you are a senior judge, but I also see a keenness to learn the way you address the session. And with this, I think the mindset, the High Court is definitely going to benefit under your leadership, ma'am. We are privileged to have you. Thank you so much, ma'am.
Thank you, Chirag. Thank you. Okay.
Yes. So with this small note, I would like to come back to the panelists for the day. Very good evening to one and all. I welcome all the participants and the panelists for this session. Can I request all the panelists to open the video now? Yeah, so it's already done. So now we have already heard Justice Mittal, and we know that artificial intelligence and blockchain are the buzzwords. And there's a lot of curiosity around these concepts. And while there is curiosity, there are also a lot of concerns pertaining to privacy, confidentiality, due process. But one thing is sure, that these methods are going to revolutionize the justice dispensation methods, and especially access to justice. And to discuss some of these issues today, we have a wonderful set of panelists who are the experts in the field of artificial intelligence and blockchain. We have with us Madhvendra, who is a chartered engineer. He's an arbitrator, trainer, consultant, and a keen researcher. You have already heard that even Justice Mittal quoted her. So that's the reach of his research work. He's a respected fellow at the Chartered Institute of Arbitrator, London. His profile can go long and long, but excuse me, Madhvendra. So the next panelist we have with us is Ben, who is an international dispute resolution lawyer, a chartered arbitrator, a mediator. He's also a partner in the dispute resolution department of Mission Diria LLP, and is the chair of the London branch of the Chartered Institute of the Arbitrators. Ben, we are privileged to have you and to have continuous engagement in various universities endeavor. We also have Alassandro with us. He's a tech entrepreneur with a legal background. He's founder and CEO of Giaretta and several tech initiatives. He's an advisor for public and private entities such as Oxford University, Astana International Financial Center, San Marino Innovation, and many more. Definitely his tech legal background is going to enrich today's discussion. We look forward to hear from you, Alassandro. And at last but not least, one of our distinguished guests, Dr. Paresh. He is the Director of Education and Training at the Chartered Institute of Arbitrators. He was also a senior lecturer at the University of Westminster, and his research interests include artificial intelligence, robotics, ethics, and law. To the participants, I would like to inform you this session, we have approximately 40 minutes from now. We are going to conduct it in the question and answer format because we have less time. So I would request my panelists to shorten your answers so that we can cover whatever is decided, and I'll be posing the questions to you. And at the end, if some time remains, we may take few questions from the panel, from the participants, and I would request participants to post questions only in the chat box, and I'll be picking those questions and then I'll be posing them to the respective panelists. With this small note, I would like to directly start with my first question, which is to Madhvendra. Madhvendra, again now, Dr. Mittal has talked a lot about AI and blockchain, but I want to understand from you that if you can explain to our audience that what are going to be the advantages and the disadvantages of the blockchain and AI, especially in the context of efficiency and transparency.
So Chirag, thank you very much. Thank you for your introduction, and a warm welcome to all the participants. Just for a few seconds, I'm very thankful to Justice Mittal also. One thing I know about her is that she is the embodiment of resilience. And I'm also delighted that she actually got time to read my article. Thank you so much, Justice Mittal. And Chirag and Neeti, both of you for putting this together. All the participants for coming in to share all your knowledge. Thank you, everyone. So let me, for the benefit of the participants, start by describing what artificial intelligence is. To put it in a definitive kind of a form, artificial intelligence is basically where computers can learn without any explicit programming. So you know how the migration happened. We were in colleges and we were doing the hard coding. We were trying and writing all those loops of if this happens, do that, else do this. So, and we also know of the Moore's law, the Crider's law, the computing powers, went up exponentially. The storage capacities of computers went up. So computers could do a lot, but the programming could not be done for you can't be programming for like thousands and thousands of lines and millions of lines to basically resolve complex problems. So what came to our rescue was the study on data analytics, where we utilized some statistical tools and some stochastic models to basically embed in the programming itself, where the computer could learn on its own and it could adapt. And in cases, the computer could find the pattern in the data itself. And whenever you put a new data, the computer would know what pattern to apply, what box to apply, or what processing to do on the data and give you a desired output. So that process was called machine learning and the data mining. And where does the blockchain fit in this? The blockchain is like Ethereum blockchain provides the network of peer-to-peer computing and also the decentralized apps, which could, we could create bespoke programs to address our specific needs. Like even in the terms of arbitration process, like things like document management, like real-time transcriptions and preparation of briefs. We have been doing e-discovery for a long time, and even small things like drafting of agreements and document forensics. How do you know what document is original? And you always knew with the advent of blockchain, one thing is for sure, you always know where the data generated, the genesis of it. Now imagine this situation. You know how many people use internet? It's 40% of people who have access to internet. On the contrary, how many people have access to justice? It's less than 15%. So I wonder, why can't we utilize internet to basically provide the ease of access to justice for all the people? Now, the concerns I understand, like Justice Mittal also described a few concerns about biases, about deductive reasoning. So one question would remain that how do we address this fourth party or this digital person vis-a-vis the natural person or the legal person? So as far as I understand from AI and blockchain, the much is not of concern except for the reasoned award, the creation of a reasoned award at the culmination of arbitration. So the deductive reasoning based on logic is what we are looking at, but don't be disheartened because work in progress is on neural networks, which are being crafted on psychological profiling of human brains. We are utilizing contractual models and things like explainable AI, that is, we call it XAI. So these are the things which would remove and mitigate these concerns of people also. And then I think the computers can do much more. As far as the adjudication process is concerned, see, what this is going to do is, it is going to create a system which is free from discrimination and any kind of censorship from a third party. And these technology are like simple, they're modular, they can fit for any requirement, and they're universal. They'll be applied universally. Like Justice Mittal also said, we need to understand the law in similar terms across the world. And they will also help us in not only assisting with evidencing, but they will also ensure, which is the most important facet of an ODR, is that the due process is maintained. And then all this paraphernalia with an integration of suites for information exchange, for video conferencing, for exchange of pleadings, and for conduct of hearings. And now since for AI and blockchain to become so-called ICT, it has to be an embedded program, just not like what we're doing now is a remote hearing. So once they're all embedded into this whole system, the legal decision, the decision-making part of it, they'll become an ICT. And like McKinsey has also predicted, by 2022, 25% of businesses are going to migrate to blockchain. And I only hope that we are also, like the legal fraternity is also able to migrate at the same time. In the last 30 seconds, I want to touch upon some concept which is evolving in terms of AI and blockchain for ODR is something called as settlement averages. Now think of the situation. Before a general counsel has to go to a law firm, he has a platform to put his dispute description on, and then he can find out that what is his probability of success in a litigation or an arbitration. And then he is also told that what is the amount that is suitable in case the parties want to go in for a settlement. So imagine, this is beautiful. I mean, you don't have to spend any money. You just go and find out what's my probability of success, what is settlement amount. If the other party is willing to settle at the amount, I'll just settle the amount with it. Why to even go in for a complete dispute resolution or an arbitration or litigation? I think there's much more that AI and blockchain can bring to ODR. And I think we should look forward to a lot of disruptive technology and the way they work.
Thank you, Madhvendra, for explaining in such a lucid and easy language. Now I come to Ben. And Ben, to you, my question is, to what extent might blockchain help with the transition to ODR?
Thank you, and thank you for inviting me today. Just very, very quickly to respond to that particular question. Let's just highlight one further point, that we're talking about several different things that can get a bit confused. We have online dispute resolution, ODR, which is simply using the internet to deliver dispute resolution. Then we have blockchain, then we have AI, which are tools within ODR. Now, I'm a great believer in ODR. I think we will all transition to ODR in a big way for the reasons that have been explained already. Now, whether we all transition to ODR with blockchain, I don't know, perhaps we won't. But I think blockchain will help, in particular because one has to appreciate that arbitration institutions have been looking at ODR platforms for quite a number of years now. And the main obstacles to them transitioning to ODR has been fears of people hacking the system, and secondly, the stability of the system. And the institutions have been nervous about taking on potential liabilities for those two reasons. Now, I'm not a technologist, and I'm not exactly sure about how one can hack a blockchain. I understand it is possible, but very hard. But so blockchain does help to that extent, but it really helps with the stability of the system. That is the great advantage of blockchain, that it's very, very difficult. I believe it's impossible to change what's put onto the blockchain system. So in that sense, I think blockchain will help institutions have confidence in moving to ODR, and therefore will help participants gain confidence in moving to ODR.
Thank you. Thank you, Ben. A follow-up question to this, you talked about the advantages of the blockchain and the way, especially, I believe it helps in counterfeiting also. Can you also reflect on the ethical concerns which are inherent in the process of artificial and blockchain? And what could be the possible due process concerns in the use of this technology?
Yes, sure. So let's just actually take a step back from this before I start to answer the question, and recognize that not every system has imperfections. In fact, you might conduct a thought experiment and say, well, let's imagine if online dispute resolution came first, and then we were discussing about moving to having hearings in person, moving to having hearings in courtrooms or whatever. Then we would be discussing about all the problems with human judges, with all the problems with getting to courtrooms, all the delays, etc., etc. So there will always be imperfections in systems. Now, as far, so I don't think these are reasons to not adopt ODR and the blockchain systems that we're talking about today. These are just things that we need to address as time goes on. Now, I think there are two, I mean, there's quite a lot of individual points one could raise, but there are two main things that we need to bear in mind. The first is, how do these ODR systems deal with the imperfections of life? Because fundamentally, we're talking about dealing with disputes between people, and people live in the real world, and people are imperfect, and their relationships are imperfect. And it's, for example, it's perfectly possible for two people in a dispute to believe fundamentally and absolutely that they are in the right, and that they may well be in the right from their subjective position. And it's very difficult to deal with that. And there is no perfect answer to it. So how does the online dispute resolution system, that the AI, the blockchain, deal with imperfections? Now in court system, we know how it deals with it because there are various appeal mechanisms. How do we allow for, how does an ODR system or an AI system deal with those imperfections? Does it allow for appeals? Does it allow for oversight by various bodies? I'm not sure. The second point, which is a huge topic, and we could talk about this all day long, is about trust. Where do people get trust in the system, especially when it may not be transparent to them? If you look at arbitration as it is currently practiced, arbitration lawyers trust it because they know that they themselves can be arbitrators. And they say, well, I trust myself, therefore I trust the system. And that also enables them to go out and sell the system to other people. And similarly in court systems, generally speaking, judges are former advocates. So advocates see themselves in the judges. We don't have that with these systems. The systems set up by people like Alassandro, who are very, I don't really know about Alassandro, but I understand he's very, very intelligent, very capable person. But I find it difficult to place myself in his shoes because he's coming from an entirely different background. I can't see myself setting up a system like him. So there's that gap in transparency and gap in trust. And how we're going to build that trust, I'm not really sure. And particularly if we lack that trust, then we're going to fixate about certain problems with AI and blockchain. For example, there's the well-known point about bias that is built into these systems. These systems are coded by humans. Humans come to these systems, that coding exercise, with biases, racial biases, for example, and then they become hardwired into the systems. Well, that may well be true, but again, as I said at the outset, that's not a reason to throw the baby out with the bathwater. It just means we have to address that problem and deal with it.
Thank you, Ben, for that. Alessandro, I would like to ask you, you are a tech guy, and Ben talked about imperfections in the system, and he also talked about trust. Do you think definitely technology can be one way of bridging this gap, but if we go by what Ben said, there are still going to be some imperfections. What is your take on that?
Thanks, Chirag. So absolutely, I agree with Ben in his analysis, and I would like to add my own view on this topic. So regarding AI, I personally interpret the path of this technology, especially impacting over the next 5-7 years on the dispute assessment and containment side, which means that not necessarily, this technology must, bring to the robot judge, so the fully automated judge on day one. So in technology, it's really important to always consider the progressivity. 10 years ago, 20 years ago, do you remember when everyone was saying, oh, I'm not going to put my credit card online on Amazon because maybe they will be cloned or stuff like that. So I think in technology, it's always good to, see the things in a perspective of progressivity. In terms of AI, I'm really a believer in the power of, enhancing the awareness of the parties. So what I foresee, it's how AI can help to bring, in an automated way, a kind of pre-assessment of, oh, I have this kind of problem, can be solved before a judge or before an alternative dispute resolution method. How much does cost to me? How much time is needed? And eventually the AI can also create some kind of questionnaire. That is something we will work on, so that eventually the party who has been told maybe is sure to be right from his subjective perspective, maybe can be brought to think in a different way, and maybe the parties helped by technology could come to a settlement by their own. Not necessarily so. I think that the AI from day one should impact on the real process of, you know, adjudication, because that will be a really, really tough journey. Maybe by time we will get there. In terms of blockchain, I think the real, point in terms of concerns is about, you know, the privacy. And we should really, every time we talk about blockchain and some, applications, we should ask ourselves how the privacy is managed. And there are solutions that can be easily put in place. For example, you know, you can on the blockchain just, you know, store not the full data, but just the abstract version of that. So it's the hash technically. So I think so the concerns about these technologies can be tackled with proper solutions, of course. And in my humble opinion, every time we touch the topic of ODR or dispute resolution and technology, both AI and blockchain, the main concern should be regarding the right of defense. The right of defense is really, in my opinion, the first question we should ask ourselves, and we must be sure that the online procedure, whatever it is, allows deeply, you know, the expression of this right of defense from the parties. And I think there are several ways for ensuring that. Last point, let's also remember that we can use technology and put at the end the human. So the human is enhanced, but there is always a human to double check. You're on mute.
So as you said, at last, after technology, there's a human. So even to start technology, to unmute myself, a human touch is required. So now I would like to come back to Paresh. And Paresh, we are talking about blockchain, we are talking about smart contracts, but do you think these smart contracts are smart enough?
So thank you for Chirag, and thank you for the opportunity of presenting today. So the question is, are smart contracts really that smart? And I think that points to another question. Well, what is a smart contract? So if we begin by looking at what a contract is first and foremost, then a contract is of course a series of promises or conditions that take place over a period of time. So if A happens, then B, then C, etc. So something as simple as if you and I enter into an agreement, into a contract, that you'll make something for me on receipt of payment, then if I pay you, you'll make that object for me, you'll deliver it to me. Once it's delivered to me, of course, your obligation doesn't cease. It has to be of satisfactory quality, of good use. So essentially what a contract is, and I'm sure we'll all appreciate what a contract is, it is essentially, it's a series of conditions and obligations taking place, unfolding over a period of time. And of course, that's fundamental when it comes to commercial relationships, that we need to have that certainty that if we do enter into transactions or agreements with other individuals, with organizations, that those relationships that we come to depend upon and rely upon can ultimately be enforced. And by and large, the contracts are of course a manual process. Some parties negotiate, they enter into discussions, they come to a series of agreements. Those agreements are then rendered into a written form or into a contract, whatever form that might take. It's the parties that monitor the performance of the contract. And if there's a breach, then it's the parties that identify breaches and might, for example, go to arbitration or go to court to enforce those obligations. So by and large, contracts, as we all understand them, are manual processes. So what's a smart contract? I mean, what a smart contract does, it ultimately takes those series of obligations and conditions that take place over a period of time and renders them into code, so that the machine itself monitors whether a particular condition has been fulfilled, and if it has, then it triggers another condition and so forth. Something even as simple as going back to my previous example, we enter into an agreement whereby you will make something for me on receipt of payment, then I might make the payment into a bank, and then the machine would ultimately monitor that. It would notify you, and then you make that thing, and then you might enter into onto a system that it's been fulfilled, etc. So that's a machine, that sort of code, maybe not the best of examples, but what a smart contract is that it's a piece of code that basically monitors that something's been done. If it's been done, then it triggers a series of further transactions. So it doesn't rely upon humans as such to monitor performance. It's the machine that monitors it, and that's what makes it smart. So can we call that a smart process? I mean, is that piece of code which is ultimately triggering those obligations, and can we call that whole process a smart process, a smart contract? And of course, the word smart is a play on words. Smart can mean self-monitoring, or smart as in, of course, something that's good. Certainly it's smart because the machine monitors performance. So therefore, rather than human beings having to trigger or identify, has a payment been made, has something been delivered, was it of sufficient standard? I mean, even something as subjective as standards can potentially be rendered into code. Has a certain quantity been delivered, can ultimately also be programmed. So in that respect, it alleviates the individual, the human, from having to monitor performance, and it's the machine that can monitor performance. And by the same logic, the machine monitors the breach as well. So rather than humans having to say, well, something's a particular condition hasn't been fulfilled, it's the machine that identifies the breach. So if, for example, the contract relied upon payment at a particular date, and payment hasn't been made at that date, then the machine can identify the breach, and potentially the machine can also sort of trigger a remedy, so that if the parties could program into the smart contract, if X isn't received by a certain date, then Y would follow, and that could potentially, some remedies could also be programmed into the smart contract. So from those perspectives, of course, one can call it smart, certainly from a self-monitoring and self-execution perspective. There are other ways in which smart contracts are not so smart, of course, because ultimately it does require the human to program the contracts in the first place. Of course, we can have machine learning based systems in the future where the machine itself can learn and sort of build in the various requirements in terms of enabling that contract to be fulfilled, but ultimately maybe not so smart because it does require a human to essentially write the piece of code for the contract. It's also maybe not that smart because, going back to a point that was made earlier, can machines do nuances and interpretation? So whilst a smart contract might say that upon payment, a certain set of goods should be sent, the goods might be received, but yet they might not be of satisfactory quality, or there might be something wrong with them. Can a machine then pick up those nuances and basically subjective perspective of people as to whether they think that something is good, fit for purpose, etc., which of course are fundamental elements certainly of sale of good contracts, satisfactory quality. So machines can't do that. Tactics, I mean, in a commercial relationship, if there's a breach, parties of course ask themselves, well, is it worth damaging our business relations to ultimately enforce this contract, to go to court, to go to arbitration? So there might be tactical reasons for not enforcing a breach of contract. So whereas a machine, I mean, to what extent can we program in those tactics into a machine, which might be commercial, subjective tactics, which are important in contractual relationships? That being said, certainly smart contracts are efficient, they promote efficiencies, so that rather than humans having to basically monitor every step of the performance of a contract, machines can take over some of that burden and promote efficiencies. And in that respect, certainly save upon costs, because there's a cost element to a human having to monitor the performance of a contract. Even as something as simple as paying somebody a salary or a wage for them to basically monitor whether something's been done, well, can a machine do that? And there's loads of things out there as to whether automation will, lead to changes in the way that people work. But there's efficiencies and there's cost elements and to smart contracts. Whether they're good or bad is to be discussed, but certainly they can promote efficiencies. they can be very useful in project work where, you know, construction projects, for example, rest upon a series of subcontracts and the performance of which have knock-on effects. So insofar as a machine can facilitate the monitoring of those various subcontracts in a construction contract, then it can promote certainly project-based work in a very efficient manner. I'll end with 3 final thoughts. First of all, what does this do to skills? I'm conscious that there are maybe many students on this particular webinar. And of course, at law schools, at universities, we teaching someone about contracts, how to negotiate a contract, how to draft a contract, how to monitor breach, how to then, you know, if there is a breach, how to go to arbitration, go to a court and argue about that breach, of course, fundamental legal skills. If all of this is now being transferred, well, if elements of this is being transferred to a machine, what does that then mean in terms of the legal skills that students have to learn? I mean, is it incumbent upon law schools now not just to teach the hardcore legal skills or the traditional legal skills to students? Now, should law schools look at introducing coding or smart contracts or technology into their curricula, given how prominent these things will become in the future? What is it? Second thing, what does it do to a client-lawyer relationship? I mean, a professional relationship is ultimately one which is based upon an individual trusting the skills of a professional who's obviously experienced, acquired those skills over a number of years. And so therefore, when an individual goes to a lawyer, they go there based upon professionalism, trust, etc. So what does the advent of smart contracts, other forms of technology do to that relationship? Can clients have the same sort of qualitative relationship with a machine as they can with another human being? It's a question that needs to be asked. So what does it do to the professional relationship between clients and lawyers? And the final thing, which has been, of course, raised before, is security issues and ethical issues, which colleagues on the panel have gone into. Certainly, for the same reasons as I mentioned, for the professional reasons, the ethical relationship. I mean, of course, lawyers are bound to act in their client's best interests. It's a fundamental ethical principle of nearly all ethical codes that lawyers are bound by. Can machines do best interests of the client in the same way? Or does there have to be a human at the end of the chain who's responsible for that? And so that trust element, that security element becomes important. So going back to the question you asked at the beginning, are smart contracts smart? Yes, they are from certain perspectives in terms of efficiencies, costs, facilitating project work. But in many respects, maybe what's smart remains with the human. Chirag, you're on mute. Okay.
Sorry. So Madhvendra, I would like to take it forward from the point where Paresh talked about self-execution part of the smart contract, especially taken it in light of COVID-19 and the moratoriums which we have on the payment of various transactions. But what will happen with the smart contracts? Payment will inevitably be conducted because the code is set. So do you think that one of the party will always be at the disadvantageous position in such a scenario? And especially one more circumstance where Paresh talked about the quality of the product, which is received is not of an optimal quality, but the payment is already made because the delivery has been done.
Chirag, you've given me 2 minutes to answer this question. I'll try my best. So I just want to very quickly say what Ben was talking about trust. So Ben, for any technology to become an ICT, to be called an ICT, there are 3 important sides of a triangle that needs to be qualified. And one of them is trust. Trust, convenience, and expertise. So I think when a technology becomes ICT, those considerations would be made. So now, Chirag, are these smart contracts smart? So let me, I'll give you an example and I would like you to be the judge. So before that, see, any contract has to meet 3 fundamental requirements. There has to be an offer, there has to be an acceptance, there has to be a consideration. And that's where the consideration part is, where the blockchain comes to our rescue, because any transaction which is done on blockchain is secure. Otherwise, how would you do it? So smart contracts are just a set of functions and state variables which are residing on blockchain. And these decentralized apps are the automated, will allow the automated execution of these transactions. So now my example to you, Chirag, is, let's say you want to replace your car with a Tesla driverless car tomorrow, which is completely IoT driven, okay? And you have taken a car loan for it. And tomorrow you go to your friend's house and your installment is due and you don't pay your installment. When you're coming out of friend's house, you don't get access to your car. It's a self-executing contract. So that's how the contracts, smart contracts are working. There is no third-party intervention. You don't pay your installment at a particular time, you don't get access to your car. I only hope they allow you to go back home after that. So another thing, another smart contract, see, we are all buying music from iTunes. But you can't say that I'll buy music from iTunes and then I'll distribute among all my friends. That allows the music to be played only on a certain number of devices. That's a self-executing smart contract. So I would let you be the judge here. I think smart contracts, as far as the dispute resolution is concerned, and we have taken care of these 3 factors of ICT, the 3 factors of contract execution, and where all the payments are being done on blockchain, the considerations are good, and the satisfaction of both the parties being there, I think the ODR should work pretty well.
Thank you, Madhvendra. Let's move to next question, which is again on a decentralized application, and my question is to Alassandro. So how blockchain can be used in arbitration, and what could be the role of D-app in this?
Sure, thanks, Chirag. So, I mean, I would like to start from, the point about the trust, that was mentioned by Ben, by Madhvendra, and generally speaking, blockchain can really increase the level of trust between stakeholders, users, for let's say, one of the most powerful characteristics of this technology, which is transparency. So one key element I always like to remark is that on the blockchain, also the smart contracts are not only automation, smart or less smart, but they represent auditable automation. So the auditability is really important. What do I mean? Whatever happens on the blockchain, it depends, of course, if it is public blockchain or private, but generally speaking, let's say it stays there immutably. And if it is a public blockchain, anyone can go there and check what happened exactly on the blockchain itself after 1 year, after 10, and unless, all the ledger is broken, eventually after hundreds of years. So in terms of, benefit of blockchain for arbitration, I would like to distinguish from a theoretical perspective 2 different hypotheses. The first one is to improve, let's say, to make more transparent eventually some phases or aspects of arbitration. And that is really important, not thinking, in my opinion, at the current arbitration or ODR. What do I mean? If you think let's close our eyes, let's imagine 5-10 years from now, if the digitalization, so the ODR by itself in arbitration takes more, market shares compared to today, eventually there will be a critical mass higher for arbitration, also impacting on smaller size disputes. So this is also a change that must be considered. In that specific case, to enhance transparency, it's crucial. And also in a globalized economy as per today, and in a more globalized as it will be in 20 years, if I have a dispute regarding, a peer-to-peer maybe deal that I made for buying a kind of device from Germany, and I'm currently in Dubai, and I need to open, let's say, a dispute or a ODR dispute in Germany, I don't know actually maybe how much reputable is one specific, institution for doing arbitration, unless it is a super famous one. So to be sure that transparency is respected, it's a really big value. How can we do that? There are plenty of ways that also we are working on in terms of our R&D. Let me give you an idea. Let's think for a while, an ODR procedure, so like an online trial, of course, an arbitration, let's say, procedure, where every phase, for example, when the parties accept and sign the arbitration agreement, or when, for example, the arbitrator, for example, I'm deeply sorry. I don't know who is. Probably is the oldest justice who is coming here saying, look, stop there. Okay, but I'm not going to answer. So to make it really short is, if every phase of the arbitration is blockchain based, you can track actually every consensual expression of, for example, the arbitrator when says that he's not incompatible with that specific case, and so far and so on. In terms of dApps, that is the second area. I mean, I think that maybe in a few years, it will be more impactful on arbitration or other digital platforms. And here it comes not only an incremental, let's say, technology application, but something new. So let me give you an example. Don't you think that maybe in 5, 10 years, or even in 2, it would be really cool if for small disputes, a kind of arbitration system, an ODR one, appoints the arbitrator in an automated way? And why blockchain is needed? Because if you have on a centralized server a randomized selection of the arbitrator according to certain parameters, the owner of the platform might change that. But if it is on blockchain, if I'm the platform, I can't cheat on that. So these are my 2 examples, and I could of course speak much more because that's what we mainly do at Giaretta, but to give you, let's say, an overview of why it can be used. So for incremental, let's say, implementation, for example, giving an auditable track of the arbitration, deeply sorry, or for exponential applications like, for example, the decentralized features. Thank you.
Thank you, Alassandro. Thank you. Paresh, I would like to come back to you and would like to take your views very briefly on the issue of decentralized education.
Thank you very much, Chirag and Alassandro. So decentralized justice, I'll say a few words, and I think that it would be remiss of me not to start in discussing something as the nature of justice to talk philosophically. So please do permit me to start philosophically in addressing this by asking the question, well, what's the nature of a contract? And as I mentioned before, the nature of a contract is, of course, a series of promises. And then the question becomes, why do we enforce some promises and not other promises? Like, for example, a friend promises to do shopping for me and doesn't do that shopping. Why can't I take that friend to court and sue them? It's because of the things that, for example, that were mentioned before. Intention to create legal relations is, of course, important. But the reason that we enforce some promises and not other promises, of course, is because some promises are deemed to be so fundamental to the functioning of various systems, such as commercial systems, that those promises are of such fundamental nature that we need to have an expectation that they will be carried out and therefore that they will be enforced. Otherwise, various systems might collapse. And of course, a centralized system made up of the 3 organs of state, especially the courts, are important in ensuring that those promises that are deemed fundamental to the functioning of systems are enforced. And the important thing that courts do, of course, when it comes to contracts, are ensure that contracts are enforceable on the basis of fairness and predictability. If, for example, the courts did not uphold contracts on the basis of fairness, then quite easily confidence in contracts, confidence in the commercial system would be undermined, and that might lead to, of course, damage to certain commercial systems. But predictability is important, and the courts, through the various principles that they might lay down, for example, through common law, are important in ensuring that we do have a predictable series of principles, offer, acceptance, consideration, intention to create legal relations, etc., which enable parties to enter into commercial relations with the confidence that what we are putting together here by way of a contract can be enforced. So predictability and fairness are 2 things that the centralized system helps us ensure. Now, smart contracts are good, and certainly smart contracts contained on the blockchain do facilitate trust and do facilitate confidence. But going back to a point I made earlier, if, for example, there were a breach and parties were to build in remedies into the smart contract and into the blockchain to enable that breach to be resolved, then that means that that's one case that can't go to court. And that's one case which might have a series of facts that might enable principles to emerge. And those principles might not just be important for that one localized contract, but might be important for similar contracts and of a nature. So therefore, looking into the future, smart contracts have their benefits, but what will that do to a system of centralized justice and a development of principles, especially through the common law? One needs to then contrast decentralized justice and centralized justice in terms of the development of the law and the principles and the way in which the law will grow in the future, especially if certain contracts are kept within localized blockchains and are codified via computer programs. How will that impact upon the development of centralized justice and a court system and common law? Of course, one way to mitigate that might be to have robot judges to kind of program justice, program principles directly into machine-based judicial systems, which themselves can render what is appropriate, what is right within a particular dispute on the blockchain. But then the question becomes, what effect will the decentralized system and the greater use of smart contracts have upon the growth and development of the common law upon a centralized based system going into the future?
Thank you, Paresh. Dear audience and panelists, because of the paucity of time, I will directly take some of the brilliant participants' question so that we save the time, and I'll start from Ben. So there's a lot of conversation about AIs being arbitrator. Now, there's also a conversation that we should have civil liability for the arbitrators. AI is a person or not a person is not clear. At least the legal regime does not define that. So in that context, how can the liability of AI be determined if they happen to become arbitrator?
Thank you. So I think that's an incredibly difficult question, and I don't know how to answer it.
Please make it very short.
Let me answer it a slightly different way. I believe we will probably never see an AI arbitrator. I'll tell you why I say that. I think we lack the imagination for an AI arbitrator. Let's take it might sound quite flippant, but I'm going to refer to science fiction here, to Star Trek. If you watch Star Trek and you see Captain Kirk, when he moves around the galaxy, steps in a transporter machine. That's insane, utterly insane, that he trusts his body that the atoms be scattered into the universe and come back together again. But we accept that. But when Captain Kirk deals with justice, he's always put in front of 3 judges. And similarly today, we entrust our bodily safety to cars, to planes, to all these dangerous things. And yet we don't mind that. And yet when we come to justice, when we talk about things dealing with our essential selves, our good name, our relationships with people, we find that it's too important to put in front of machines. We lack the imagination to do that. So I believe we will never see an AI arbitrator. I fundamentally believe that we will have self-executing contracts, and they'll become increasingly important, and that is fantastic. I fundamentally believe we will see computers have a greater role in predictions of outcomes, which will help people settle their cases. But to have an ultimate decider, ultimate decision maker as an AI entity, I do not think that will happen.
I think with your answer, a lot of retired professionals will be very happy, for whom arbitration is the after retirement opportunity. Thank you, Ben, for that crisp reply. Another question from the participant, and because this pertains a bit to technology, I will pose it to Alassandro. So Mr. Jain, Amit Jain asked this question. Once any transaction is entered into the blockchain, it can neither be removed nor modified from there. Is this right? If yes, what will be the process of errors rectification?
Great question. So yeah, I mean, from a technological perspective, the immutability of the transaction in general terms on DLT or blockchains, it's one clear data. So normally you should address that, let's say, not problem, I would say that feature with an exactly, equal but opposite transaction. Let's make an example. I'm sending to, let's say that Chirag is sending to me 2 Bitcoin. Please do whenever you want. If we want to reverse this transaction, I have to do another transaction, which is going to send back 2 Bitcoin to Chirag. This could be applied also with smart contracts. So let me expand the question made by our dear attendee. In case of smart contracts, when there is, let's say, a complex architecture in a smart contract, which can involve a contractual obligation, let's say that in 60–70% of the cases, you have to deploy another smart contract which is equal but opposite in terms of the purpose. There might be some exceptions. So if you create, technically speaking, more complex, let's say, architectures in a single smart contract, that could happen, let's say, without deploying a new smart contract. So for example, if you build a system where there might be there is a process according to which the money in escrow is moved in to party B, but the money is going to be kept in a second escrow. I don't know why, but until there is a second validator to come there and validate within 30 days. In that specific case, let's say it could be a preset definition which could revert, a part of a transaction, but this is really an exception. So in terms of principle, there is no reversibility. There are some projects, especially in the last years, that try to address that let's say, feature, but at the end of the day, or you want the immutability, and so you have to take this part, or you don't want the immutability. If you look for middle, let's say, solutions in the middle, maybe you don't probably need really a blockchain.
Thank you, Alessandro. Now, another question, and I would like to ask this question from Paresh. There is a lot of discussion about access to justice. But in India, concern is also about access to technology. So how to reconcile this?
Certainly, that's one of the key considerations from an ethical perspective as to what, there is technology is obviously a very good thing, and there is a clamor amongst lots of people to kind of introduce technology into the legal space. And certainly for the reasons I've outlined before, there are many benefits to that. And of course, access to justice, it can facilitate access to justice. There might be people who otherwise might, for example, feel frightened to approach lawyers, or might not have the costs. Technology also has the potential to minimize costs. So it also has great benefits in facilitating access to justice. But at the same time, we have to look at the other side of it, that there are people out there who might not have access to the technology that they need in order to ensure that they can access those services that are now being provided. I guess then it's incumbent upon the authorities really to kind of put in place the programs that are needed to ensure that those who might not otherwise have access to technology, whether it be computers or broadband and other sorts of facilities, can access those. And so maybe having a nationwide program introducing something which facilitates. I know lots of countries are investing tremendous amounts of money into building up their internet infrastructure for that particular reason, because it's not just in the space of law, but also in the space of education, where this is important as well, that technology facilitates not just legal services, but educational services. And it's important that everyone has access to those opportunities. So I think that what goes hand in hand with greater technology is a responsibility upon lawmakers, upon government, and upon local authorities to ensure that we have the relevant infrastructure and investment in place to facilitate the access to technology in order to ensure that we don't have two speeds develop.
Thank you, Paresh, for your perspective. And now I ask the last question of this webinar. The question is Madhvendra. It's about interpretation of the smart contract. Whose intention should we consider while interpreting the smart contract? intention of the maker or intention of the programmer? And if we consider the intention of the programmer, how problematic that may be? I'm not sure, but this is the question posed by Chaitanya Shah. Madhvendra, mic.
Okay, so to put it simply, like I have been saying, that lawyers who are not conversant with this technology and the engineers who are not conversant with the law. So are we going to call these lawyers who start to code the coding lawyers of tomorrow? Or the engineers who start working in the law field, or the engineers who become arbitrators, will they be called as the contractual engineers, or vice versa? So it's not going to be the one side who's going to be engaged in development of these smart contracts, the coding part of it. So basically it has to be a collaborative effort of both sides. And from the fundamental knowledge, we have to basically develop the codes based on the fundamental knowledge of the experts in this field. And then when the coding is being done, the people, let's say for a particular example, we are doing the contracts law, coding for deciding the commercial contracts based on the Contracts Act of a particular jurisdiction. Somebody who's really an expert in that field and what kind of jurisprudence that has evolved in that jurisdiction and internationally, especially for international arbitration, will really have to get into the nitty-gritties of that coding part of it. And I'm sure it will go through various iterations before it is put to test. And like I said, the three features of ICT also, the trust, the expertise and convenience, they all have to be taken care of. So we can't say that the coders themselves in isolation will build these smart contracts. There has to be a collaborative effort from all the stakeholders. And once we have reached a level where there is a mutual understanding of the fields with everybody, we come to a level where lawyers understand this technology and the coders understand arbitration equally well. I think that will be a time when we can say that just build any commercially off-the-shelf product, smart contracts, and pick it up, we integrate with our business, and we move on with that.
Thank you, Madhvendra. And with this, I would like to thank all the esteemed panelists for sparing their time, and thank you to all the participants for bearing with us for extra 15 minutes. I would also like to sincerely thank Neeti, who agreed to make MCIA as a supporting partner, agreed to introduce the session and bring Justice Mittal on board. My sincere thanks also go to Lawlex organization for aggressively sending the invites and advertising the brochure and the poster of the program. And at last but not least, the big thanks go to himself, who conceptualized the program. It was his idea. He brought everybody on board, and I'm thankful to all of you. I look forward to have similar programs with the help of all of you. Thank you so much.
Thank you so much. Thank you, Chirag. Thank you, everyone.
Thank you very much. Thank you.
Have a good day, everyone.
Bye.